May I please, Lordship?
Yes.
Lordship, I beg to mention item number 2. My senior Mr. Ekedas got some injury in his leg yesterday morning, Lordship. So, Madam is praying for adjournment.
2012 matter.
Yes, Lordship.
Anything survives?
Lordship? Praying for adjournment.
Huh?
Praying for adjournment. Yes, he got some
That is
injury.
2012 matter.
Yes.
Hmm?
Only for 2 to 3 weeks, Lordship.
Only for 2 to 3 weeks.
Yes, I'm not saying much, Lordship. Because he got some injury in his leg, Lordship. Yesterday morning.
On the prayer of Mr.
MJ Gogoi.
M.G. Gogoi, Learned Counsel for the M.J. Gogoi, Learned Counsel for the petitioner. List this matter after 3 weeks. After 2 weeks is the arguing counsel, Mr. Ekedas,
Yes.
is reportedly sustained some injuries.
May I please, Lordship? Item number
Since the matter since the matter is pending since 2012, no further adjournment shall be granted on it. It's last chance.
Okay, sure.
2012.
Lordship, item number 12.
And, sorry to interrupt, Lordship. There is a record. Record may be kept, Lordship. On
May I please, Lordship?
Yes.
Item number 12, it may be taken at 2 p.m.
Why?
Look, I have some medical urgency for quite some time. I will be outside of the court.
Well, why?
Lordship, in fact, I am a diabetes patient, but I have given the PP.
It's
now.
2020 matter. If you have some difficulty, we'll adjourn.
Item number 12,
Yes, 2023 matter.
23 matter.
Yes.
I'll appear at 2.
We cannot. On your wish, we cannot.
Then, Lordship, a date may be fixed.
2023. What is the matter?
Termination from service.
It's listed today. You are joining. Seeking on the prayer of Mr. F.J. Majumdar, then counsel to the petitioner. This matter after 3 weeks.
Can it be up to 2 weeks?
Is on the ground that he had to visit the doctor.
May I please, my lord? My lord, item number 13, my lord, 13. This matter may be taken up after 3 weeks, my lord.
Why?
We have some difficulties today, my lord. This matter will take some time, my lord, for hearing, my lord. It will take
On the ground of personal difficulty, Mr. H. Chaudhary, learned counsel to the petitioner, prays for adjournment of the matter. Praise the Lord. Let this matter be listed after 4 weeks.
Obliged, my lord.
May it please, Your Lordships?
Yes.
I'd like to mention item number 3 of the daily list, Lordships. I've
Three.
met the senior counsel, Mr. Didas. Lordship, he is in Arunachal for a partner matter. So if it is not inconvenient to Your Lordships, can it be next week, any day, as per Your Lordships?
No, I'm inconvenient. We'll take it up today.
Lordships, today there is some difficulty, Your Lordships.
Item 3.
Tomorrow, Your Lordships.
Anyway, on the prayer of Miss M.S.
S. Sharma on behalf of Mr. Didas, senior.
S. Sharma, appearing on behalf of Mr. Didas,
Yes, Your Lordship.
the senior counsel for the petition. Submits them. No, I said no. M.S. submits them. See, her senior Mr. Didas is out of the station. Mr. Therefore, she prays for listing of the matter after 3 weeks. List after 3 weeks.
May it please, Your Lordship? With the consent of other side, I'd like to mention item number 4, Lordship. My senior petitioner is unwell. He's an arguing counsel. So, matter may.
What happened?
He is sick in fever. He is suffering from fever.
On the ground of Mr. P.D. Nair being counsel having some medical problem come up. Mr. G. Alam,
I'm S.I. Nasir.
Nasir.
on his
Let
behalf.
me consider appearing on behalf of Mr. P.D. Nair. Press for adjournment of the matter. Mr. President, this up to 4 weeks.
Highly obliged.
May it please your Lordship. Lordship, I beg to mention item number 11 of today's daily list.
Yes.
Lordship, there's some personal difficulty on our end today on behalf of the NHM authorities. Lordship, can this matter be taken up at a later date after vacation?
What authority?
Lordship, the arguing council is out of station, Lordship. That is why. Brief is also with them only, Lordship.
On the prayer of Mr.
M. Bhuya, Lordship.
M. Bhuya. Then consider appearing on behalf of Mr.
It will be Miss A. Bora, Lordship.
Ms. A. Bora. For your A. Bora is
A. Bora is not there, Lordship. I'm
Oh.
M. Bhuya. A. Bora is NHM, Standing Council of NHM.
Standing Council. NHM. Having some personal difficulty. Justice matter. 3 weeks.
Lordship. Much obliged. We take into consideration the other side, Lordship. Much obliged, Lordship.
Yes.
May I please, your Lordship?
Yes.
Lordship, order under challenge is at Annexer 7. This is 27/1/2016.
Page 27.
Lordship, it is page 47, Annexer 7.
Yes.
With reference to the above, it is informed that as you are aware of the Honorable Guwahati High Court's decisions regarding your business place at Chowk Bazar, as such, complying with the said decision of the Honorable High Court, it is hereby informed that you shall vacate the said business place within a period of 15 days from the date of receipt of this letter. It is informed regarding your place of business that if you can show any alternative place of business within the municipal area, then municipal board shall consider your plea without harming the public interest. This is under challenge.
What's wrong?
Lordship, the High Court's order is not like that. The High Court's order is at page
municipal board shall allow him to set up shop at the appropriate place, taking into account the earlier orders passed by this court.
a series of the orders passed in this regard, and the duty has been.
You first vacate, then.
Lordship, that is not the precondition. Is that they should allot me another place because I cannot find out the
You
place.
see, page 46. The petition shall vacate the shop premise under his occupation at Golaghat Municipal Chowk Bazar.
Golaghat Municipal Chowk, the municipal board
Then
shall
only-
allow him
then
the,
only-
unless
Then next is.
the
allow him
Golaghat
to
Municipal
set up
Board
shop
shall
premise.
allow him to set up the shop. Both should be read together because once I cannot get a place, I cannot vacate it because that is my livelihood. That is why this was considered.
You
And
find out.
so it starts from the first order is at page
First of all,
20.
what is your right to be considered?
Lordship,
What is the basis of your right?
by basis of right is that is based on a judgment passed in the title suit. So page 20. So accordingly, the suit is dismissed. That is at page 20. It starts from 1995. So accordingly, suit is dismissed and defendant municipal board is directed to provide alternative accommodation to the plaintiff in pursuance of the Honorable High Court. There was an order earlier that was considered and that was passed in the year this title suit judgment was passed on 23/6/1997, and thereafter again there was a MFA. Miscellaneous first appeal was there. It is of 7 of 1999. This was disposed of by the order dated. It is 10th March 2003. In this order, also in the above premises, the operative portion is that in the above premises, the title suit number such is partly decreed directing the Golaghat Municipal Board to allow the respondent number 1 plaintiff to set up his shop in the vegetable market on payment of the requisite fees in accordance with law. The Golaghat Municipal Board would do needful in terms of the decree within the period of 2 months from today. let the decree be prepared by the trial court in terms of the above impugned judgment order is set aside. No order has to pass. So it has cast a duty upon the municipal board to allow a mere place within the municipal Golaghat, directing the municipal board to allow the vegetable market within the vegetable market. Now what they have, this impugned order has been passed. This is the basis on the basis of which the subsequent orders were passed. Now the last order, the last letter which is impugned, they are saying that within the municipal area. They are not saying that it is within the municipal Chowk Bazar, vegetable market. So, and Golaghat Municipal Board is totally silent. They have, despite of repeated notice, they are not coming. Your second step, I took second step for the second time on 21/9/2023, as per the order of the Lojima Court. They are not coming.
It has been served.
Yes, Lordship. Because they were sent by registered post.
So sending a registered post will not do whether this has been served or not.
That I cannot find because repeatedly I am taking steps upon them. As per the General Clauses Act, this is deemed to be served. But whether it has been served or not, that is because I took steps through registry.
13/11/2024. As per Honorable Court's order, no fresh application to implement the necessary parties has been received.
No, that is that no trace. I could not take the step to implement the party because the chairman is already there. So at that time, it was informed that the chairman was not there. So that is why that order was passed. And if the municipality comes forward, this can be disposed of. Because it is dispute between the municipality and the petitioner, not with the private respondent. They are also suffering for this. The municipality is not coming out. Repeated notice, despite of repeated notice. And there is no standing council also, the municipality.
But it doesn't show whether it has been served or not.
Lordship, that I cannot find.
Last order. Where is your last? When did you take the step?
It was taken on 21/9/2023. If required, I can serve one notice upon them Dusty by Dusty.
This 22/9/2020, there is the order of this court that taking into account that service is completely matter to admission hearing.
So that was taken into consideration
But the office note says that the matter was laid before the court, so as mention was allowed and same has been kept on curtain. But the Honorable Court's order 29 has considered services complete, hence notice could not be issued. Notice has not been issued.
So
Because there is an order of the court that the service is complete.
I was
So
asked
you have
to.
filed the requisite copy for steps,
Yes, Lordship.
but then it could not be sent.
I have submitted it. As
You
per the
take
Lajima
you
Court's
take the
order.
You take the dusty.
Yes, Lordship.
It's better to hear them.
Yes,
Or
Lordship.
should we dispose it of?
Lordship, it is better to hear them because otherwise, if the same direction is passed, they are not going to do nothing, and respondent is also suffering for that. The respondent is also suffering for that. Private respondent.
How you are concerned?
No, I am concerned because Dispute is between
No,
me and the
if the
municipal.
respondent is suffering, how you are concerned?
I am not concerned with the respondent.
Are you running the shop still
Yes,
at the
Lordship.
same place?
Yes, Lordship.
That's the reason you are not suffering.
No, that is not there. As per the direction, I took the step. So,
You have taken the steps on 21/9,
yes, Lordship.
and next day on your it was mentioned and was switched on 22.
Lordship.
Had SN Tamil learned counsel for the petitioner, and also had who else are appearing?
Again, for the respondent number 3,
Mr. So and so.
the matter is very clear, my lord. The earlier in WPC, my lord, earlier your lordship has passed order directing the present petitioner to vacate the land, and the municipality directed to provide him with the alternate plot of land.
Yes.
And receiving that order, the municipality has issued the notice, my lord. It's the notice Annexure 7. And receiving that, as per this notice, in terms of the hearing taken in place of imminent in connecting and demand before the Honorable Guwahati High Court and newly constructed vegetable market.
No problem is there is no problem in disposing of the matter. That we would like to hear them because there are two orders of this court. To
Yes,
vacate
two orders.
and to give appropriate place.
Correct, madam. Civil code order.
So they want that the municipal has directed him to vacate, but then and Mr.
Yes, sir. ma'am.
for respondent number 3. Non appears for respondent number 1 and 2, whose appearance is required for adjudication of this matter. Next paragraph. Records reveals that although the petitioner has taken steps for service of notice on 21/09/2023, however, due to order dated 22/09/2023, indicating that the service is complete, notice could not be issued by the registry. Considering the above,
Municipality has already received notice, madam, as per Life Court order.
how do you know?
They
It
have
doesn't
received
indicate here anything. Considering above, Mr. S.N. Tamun, the learned counsel for the petitioner, is directed to take steps by dusty note within 3 days.
Lordship, 5 days because
Huh?
5 days.
Within 5 days, this time for service of notice upon respondent number 1 and 2 by
Next.
municipal corporation, municipal board,
Yes,
municipal board,
yes, Lordship. Mrs. Golakar Municipal Board.
Golagat,
Yes,
municipal board,
yes.
Golagat. This is the matter after 4 weeks.
Yeah, please, your lordship.
Yes.
Lordship, with the consent of other side, I would like to mention item number 5, your lordship.
Right.
Lordship, the conducting counsel, Mr. D.P. Bora, is out of station, your lordship. So the matter may pass over for the.
What happened? It should be over. I mean, selection process.
No, selection, initially selection was made, accordingly they were given promotion. Subsequently, the promotion was reviewed and they were reverted to the lower post law.
Why?
Lordship, some anomalies were found, Lordship,
Where is this?
while conducting the DPC.
Have you recorded this?
No,
in the-
Lordship, subsequent there to these writ petitions were filed, wherein a stay order was issued. They continued to work in the promoted post, Lordship. subsequent-
Assistant executive engineer.
Yes, subsequently they were given promotions also, which were made subject to outcome of the present writ petition. On last date, Lordship, on last date means 2-3 days back, Lordship,
18/6, 18/6.
18/6, they made a submission that this, as they are already spent sufficient amount of time, Lordship, and the things has got stable now, they want to withdraw the petition, Lordship. But Lordship, once the petition is withdrawn, that stay order will go. So in that situation, they will have to join the earlier post. And accordingly, direction was issued to the department lordship to take a decision whether the department is agreeable to the prayer made by the petitioners or not. So that decision is still to be taken, lordship. It will take some time. It is not just placing of instruction, lordship. The decision is
It's
required to be
by
taken.
lapse of time. Allow
Yes.
them what's
Ye-
there.
Yes, lordship.
Because
They're-
by operation of this stay order, they are continuing, they are earning the, the salaries, whatever.
Even subsequent there, they were given promotions also.
Yes.
But-
Maybe they don't want, they would like to have this from the date of their initial, the selection, promotion. Maybe they would like to have the promotion from that day.
No, they were given promotion from A to AEE, Assistant Executive Engineer.
No, that's what I'm saying.
That promotion they were reverted.
Reverted. And then subsequently they have been promoted.
They also, because of the stay order, they continued in the AEE post. Subsequent they were given promotions also.
From
A-
the subsequent day.
Yes.
Not from the date of their
No, that is
initial promotion.
Those are subsequent, just like other engineers. Not they were given promotion,
Subject to outcome.
which was made subject to outcome of this petition. So that is my only submission, Lordship. Let the department take some
I
decision.
think better to take decision instead
Yes.
of going into all this slum into all this.
Otherwise, if
Because
this-
they
if-
were continuing,
Lordship.
and at best, what they can be, what the government will be losing. Only the seniority, and so far the seniority is concerned, government would not lose anything.
But they will not lose seniority also.
No,
if-
suppose
yes.
if they are allowed to continue
Yes.
from that day, from the initial stage.
From the
first promotion.
Yes, from the first promotion they are continuing.
No, continuing
Yes.
is something different.
The
Subsequently,
order for reversion was stayed.
yes, that was stayed, and then subsequently they will promoted.
Subsequently also they were promoted, but
Promoted from the death of that subsequent death, not
Yeah.
from the initial
not from the
promotion.
initial,
So
subsequent.
they would like to have that promotion from that day for the purpose of seniority. Otherwise, other
No,
entitlements,
only
they are
decision,
getting it.
only decision we need to take, Lordship, whether we are ready to take back that reversion order or not.
Yes.
If that order is not given effect, Lordship, they will continue as it is, Lordship.
But then the issue would come from which date? Suppose during the pendency, they were promoted
Yes.
from that date, from the subsequent date, not from the date of initial
No,
promotion.
Lordship may kindly see in the affidavit we have given the date.
Yes.
DPC said on 10 to 2014
14.
in my affidavit, Lordship.
No,
Lordship.
just wait. What is the promotional that thing?
At that they were given promotion to the post of assistant executive engineer,
Assistant executive.
from assistant engineer to assistant executive engineer. But that promotion was subsequently found
No, I'm asking which from which date they were promoted.
promotion on 10 to 2014, Lordship.
No, 21/11/2000.
Yes, recommended on 10 to and given promotion on 2011-2014.
Also, what is the impugn order?
Lordship, I kindly see page 21. Petition. Effective portion at page 22. Last portion, Lordship. The selection board decided to recommend to revert back the following officers to their original cadre, that is to the rank of assistant engineer.
Seven of them.
Yes, 7 of them. Lordship, this order was stayed, Lordship. Accordingly, they continued to remain in the post of assistant executive engineer.
this promotion were on the same day, all the read petitioners.
Promotion was on 2011-2014, Lord.
Yes, I'm saying, on the same day.
Not same day, Lordship. DPC was on 10/2/2014.
Impugn order is same.
Impugn order is same, Lord. I mean,
But they were promoted
yes. DPC was up
in
to
2014.
yes, 2014 to 2016 they continue. 16 days reversion order was passed.
Yes, I'm not sure.
This order has been stayed, so they
They're
continue.
continuing. In
Thereafter,
the meantime,
they were
they
given-
also promoted to
Yes,
the
just-
regularly again promoted.
Yes, just
I
like that.
think perhaps they would like to have this reversion is under challenge.
Reversion is under
they,
challenge.
may, they may like to have
Yes,
the
but
date of promotion from the date of their initial promotion.
they continued from 2011-2014. Reversion was on 6 February 2016. So 14 to 16 they continue, and because of the stay order they continued from 2016.
So
also.
that's what I'm saying.
Yes,
As on today, so far practically they are serving. And in the meantime, even after in view of the stay order of this court,
yes,
they are continuing. In the meantime, you have promoted them again.
yes, Lord.
But then now practically they are in the post.
They are holding.
They
the
may would like to have from the date of their promotion.
yes, from 2014 to 24, it's almost 10 years. Lord.
Yes.
So they want to withdraw the petition.
Hmm.
But only question will remain if the petition is withdrawn, that stay order will go.
Hmm.
So accordingly, we need to take a decision.
No, if the stay order will go by now, they will be. They have already been promoted.
Yes, Lord.
Now their date of effective promotion effective date will be from the date of
2014.
Huh?
14 they are continuing.
no continuing is something different.
Yes.
You said after the stay of the reversion order, they continued. In the meantime, they have been regularly promoted by next DPC.
But that was made subject to outcome of this petition.
No, that's why. That's why. Now, if you will decide if this writ petition is withdrawn. You
That is-
may consider from that day only, not from the initial day.
So in my humble understanding, day is not the problem. On from which dates they will be promoted, that is not the issue. Because from 2014 itself, they continue. 2016 reversion order, that order stay. So they continued from 2014 itself. And when promotion become due to them, they were given subsequent promotions also.
That's what I'm saying.
Yes.
That's what I'm saying.
So
You will not allow them to. You will not give the effective date from the date 2014.
they are enjoying the effective date.
Enjoying is something
Yes.
different.
Yes.
Where it is? Where is the promotion? Subsequent promotion.
Subsequent promotion.
Where
Lordship-
the promotion is made subject to outcome.
Yes.
Where it is?
Affidavit আছে না? petition আছে?
Sir, are you getting my point?
Yes, Lordship. Not that those
See,
subsequent
There's
promotions-
no problem in. There's no break in nothing.
nothing.
They are continuing by virtue of the stay order after the reversion. In the meantime, you have promoted them
Yes, Lord.
subsequently.
Yes, Lord. Understand.
Apart from by virtue of stay order, there is a vacancy. In the meantime, well, they are continuing by virtue of the stay order. So the effective date will be from the date of your second promotion. I mean, subsequent promotion, where you made them the subject to outcome of the writ petition.
Lordship.
Now, once the writ petition is withdrawn, right, you will decide, probably, perhaps you will decide from the date of that subsequent promotion. Effective date of promotion would be date of subsequent promotion.
If the,
Although they have served,
if the reversion is order is appealed by your Lordship,
yes,
then they will their promotion in the year 2014 will go.
obviously,
Yes, Lord.
I'm saying when in the event of withdrawal of the writ petition, you will have to see, because you have, rebut them on what ground? There's no vacancy.
No vacancies. Some anomalies were there. Lordship.
Anomalies, obviously,
They
will
were
not-
diploma engineers.
you will not say that there was no anomaly. Now the question would be from which date their promotion shall be counted. Obviously from the subsequent date. Of course, by the
No,
authority.
if this stay order, if this reversion order is upheld,
No, appeal to no issue.
the entire scenario will change. Their
No.
seniority will be counted
No, if
again
it-
from the post of
No,
A.
if it is withdrawn, that's what I'm saying.
Lordship.
If it is withdrawn, if the writ petition is withdrawn,
The benefits they acquired in the meantime, Lordship, that will go. That is the only issue. That is why court directed us to place instruction in the form of a decision, Lordship. Whether government is contemplating to go with the reversion order or government will review that order, Lordship. So that will definitely take some time, Lordship. In the meantime, they are continuing, let them continue, Lordship. Pendency will not harm them in any way, Lord.
heard Mr.
एक ही आता है
Learned Counsel to the petition. And
टी झा
एक
all
ही
of
आता है
you,
They are subject to corruption. no?
6 and 7
6 and 7, you are 5.
हाइट
You say 5. You withdraw the writ petition in that case?
no but
Why?
we are continuing if you will do then our interim model will go
But you are already promoted.
yes
You are already promoted.
we are already promoted
After the reversion,
reversion order is here my lord.
after the reversion, you have been promoted, and then you have accepted.
No,
it.
no, madam. Before reversion, we were promoted.
No,
Then
Lord.
I understand.
No.
Without promotion, how you can be reverted?
Yes, yes, yes.
You were promoted, and
Yes.
are you thinking that I've not understood the case?
No, madam.
Now, during the pendency of the writ petition, have you been promoted regularly?
During pendency of the interim, no, madam.
That is what he's saying.
No, madam. 2014 promotion will given, madam.
Lordship, 2014, they were given promotion from AE to AE. Hereafter, he has been given promotion from AE to SDO, I think. Thereafter to executive engineer. So he got the subsequent promotion because his promotion was counted from the year 2014. So he came under zone of consideration on the basis of seniority from
First,
2014.
they were promoted from assistant engineer to assistant executive
That
engineer.
order was reverted.
Reversed.
Yes.
And they are continuing by virtue of the stay order.
Stay order.
In the meantime, you have promoted them further
Yes.
to the post of executive
Because
engineer.
they are already holding the post.
Post of executive
Yes.
engineer.
Subsequent post, Lord, a different post, higher post.
Then heard so and so. For item 5, Mr. So and so. Item 6 and 7, Mr. So and so. Huh? Just learn concept of petitioner in so and so. Next paragraph.
Lordship, I am appearing in item number 5 in respect of respondent number 8, 9, 12, and 14.
Mr. P. Naik, learned. You didn't record his name. Huh? Mr. P. Naik, learned standing counsel for the PWD. And also had Mr. P. Naik, learned counsel for learned standing counsel for PWD. Next paragraph. The challenge made in this writ petition is to the page 21.
Page 21, Lord.
To the order dated 06/02/2016 issued by the Deputy Secretary to the Government of Assam Public Works Department, whereby the petitioners had been reverted back to the post of to the rank of assistant engineer with bracket C after they were promoted in the year 2014. This court had stated in order that it's 6/02/2016 during the pendency, the responding authorities have further promoted the petitioners to the post of to the next higher post of executive engineer,
Up to executive.
as they were continuing as assistant executive engineer by virtue of the stay order. By virtue of the interim order passed by this court. This court. The further promotion to the promotion to the next higher post of executive engineer is been made subject to the outcome of the petition.
Presently.
Next, it is noticed that Mr. P. Nayak, an standing constituted had submitted that in view of the fact situation of the matter, a decision is required to be taken by the department, for which he prayed for some additional time. This court on 18/07/2020 has granted the learned standing council by fixing the learned granted time to the learned council for the learned standing council. Today, when the matter is listed called for hearing, he submits that he reiterates the submission made on 18/07/2024 that given the fact situation of the matter and considering that the petitioners have been further permitted the higher cost, although subject to outcome of the petition, an appropriate decision is required to be taken by the departmental authorities, taken by the responding authorities, for which the 6 further time of 4 weeks.
4 weeks.
You decide this. The submission and the prayer made by Learning District Council, Learning Standing Council, CWD, having been not opposed to by the Learning Council to the respondents, and also considering the facts narrated hearing for that 4 weeks time is granted to the respondent authorities to take appropriate decision. The Learned Council for the petitioner apprised and placed necessary instruction as regard any decision that will be taken by the respondent authorities in the next 8 weeks. Considering that the matter is pending since 2016. 14 also. Why 14?
16 matters.
One is 14.
14 minutes when I was not promoted. When not promoted, then I was a
Issue was different.
So
it was prior to promotion.
2014 selection was dear my lord. They have said we are not promoted. We are not given promotion. Thereafter we have filed a petition, my lord. Then we have promoted.
Then promoted and reverted.
No, promoted. 2014.
14 you were promoted.
Yes,
not promoted.
14 and the petition number 5474, my lord.
Yes, sir.
Our
2016. It is expected that on the next step, within 4 weeks, the authorities will take a final call on the matter.
Lordship.
will take a final decision on the matter. Let us see a 2014 matter.
Law 14 was Lordship prior to that they were claiming promotion.
Yes, then
Yes, my lord.
Subsequent there to promotion has been given.
subsequent when?
2014.
2014, my lord. This order, reversion order, my lord.
No. In the
Prior to reversion order.
Yes,
only.
lordship.
Huh?
Yes, yes.
Then it will become in process. We'll
Yes,
close
my lord.
this. It has become in process.
Yes, yes,
it
yes.
will from- it will-
We call
it
it
will-
that other one.
because of
That is which item?
items
Item 6.
6.
5474.
2000. It has become in process.
My lord, my lord.
Not Mr. That is items 5 and 6, 5 and 7. This order will be in 5 and 7. Item 6, not Mr.
AK Azad.
Huh?
AK Azad.
A.K. Azad. Not Chandrasekhar Azad. A.K. Azad, and counsel for the petition. Not her. Mr. A.K. Azad, and counsel for the petitioner, submits that the matter has become in process. Mr. You are in this matter? Are you in this matter?
No, Lord.
Mr. P. Nayak and Mr. Council in this matter. The represent stands dismissed as in process. Item 6. You take a decision within 4 weeks. Most probably they would like to claim the from the promotion, first promotion,
Yes.
effective date. But then one thing also you have enjoyed, you have been promoted further to the higher post. Considering that, are you apprehending that you will be reverted back?
No, no, that is why they want to withdraw Lordship. And on the last date, Lordship, when they expressed their willingness to withdraw, I submitted before this honorable court. Once these petitions are withdrawn, then stay order will go. Accordingly, court directed me to take a decision and place instruction.
Can we say that withdrawal of writ petition shall not come in view of the further promotion to the higher post, can you close the matter?
But then,
Because it will be just a formality.
then that challenge will remain unadjudicated.
But then why you have promoted them to the higher post?
Because they were holding, they already entered in the seniority list. They were under the zone of consideration. That is why we had to.
Anyway,
Lordship will consider the exact laws.
So this is a matter pertaining to departmental proceeding. On
Yes.
the last occasion, this honorable court directed to produce the records. My lord, the understanding was that, my lord, I'll also go through the records of the case because I have challenged on the ground of perversity and procedural irregularity.
that
I
is
had
the
a-
only ground.
I had a talk with my senior.
That is the only
True,
ground you can
true,
challenge.
true, my
There
lord.
is no other ground.
Yes, I had a talk with my senior, my lord. My
Yes.
senior has received the records yesterday. So, my lord, a little opportunity to me to go through the records so that I can place the submissions on my part, my lord.
He can make the submission. What is
That's
in the
that's
I
true,
got
my
it,
lord.
couple
But
of-
I also need to, my lord,
I can share it with you,
make my
madam.
submission relying on the records. So that's why my friend has already, my lord, senior friend has already assured me to give a copy of the daily order sheet and evidence because evidence and daily order sheet were not given to me at the time of inquiry, my lord.
An inquiry report was furnished.
Enquiry report was furnished, but the evidence which were considered by the enquiry officer and the daily order sheets, which were part of the enquiry, my lord, those were not furnished to me during the course of the enquiry. So that's why I requested before the courts also on the last occasion, and my friend he has assured that he'll give me a copy. 1 or 2 days time, my lord, I'll go through it and I'll place my submission. Any date, my lord, in the next week or convenient to your lordships, my lord.
Yes.
I can share it with him, my lord. Because I got it only a couple of days back, my lord. I
Not
also need.
Mr. HK Das, learned counsel for the president, and also heard Mr. N. Barua,
Barua.
learned standing counsel for the State Bank of India. Mr. N. Barua, learned standing counsel, submits that he has received the records. Mr. However, Mr. HK Das, learned counsel for the prisoner, submits that he may be given 1 week's accommodation to go through the records which the learned standing counsel, Mr. N. Barua, is ready to share with us. Next, considering that the matter pertains, considering the matter, let this matter be listed after a week.
Date will be fixed, my lord, after the
After
vacation, my lord.
Considering the submissions and as agreed to the learned counsel by the parties, let this matter be listed after a week. After a week.
After a week. Can a date be fixed, my lord? Yes. After the vacation, my lord. After the vacation, my lord.
Fine.
8 January. 8 my lord. Obliged, my lord.
Highly obliged. May it please your lordship.
Yes.
This is a challenge to a dismissal of the petitioner. He was in the CRPF, your lordship, working as a PN in the CRPF. He was appointed. I'll just go through the facts of the matter, and then this challenge is on the basis of a few small. He was actually absent from duty for 8 days in an intermittent, and on that ground he was charge seated, and ultimately he was dismissed from service. So basically, I'm challenging that. My appeal as well as the review have been rejected, and therefore I've come before this. Now, the petitioner was appointed on 2/5/2005 at page 12, the annexure 1. This is the type copy, and he was appointed the post of page 12.
What do you mean by follower peon?
Lordship?
It's a follower peon.
Yes, it's a forward peon.
What is follower peon?
It's actually, it should be follower peon, not forward peon. It's follower peon. I don't know. It's a peon. It's basically a peon, but they say they must be using a word like follower peon in CRPF. He is otherwise a peon in the office.
That's why
Yeah, even I am not very acquainted with the word.
curious to
We
know what
follows
is follower
whom?
peon.
Follower peon. First time even I have heard that. But actually, I asked him. He said he is a peon in the office at that point of time. So
Is it which state?
he was in Sipsagar. Sorry, he was appointed at Group Center Khotkhati in Assam.
Which date? There is no date, nothing.
Date is, your lord say, this was in May 2005, 12th of May 2005.
Where it is? Okay.
12th May 2005, in the page 14 it is shown.
Yes, yes.
So after that, your lordship, he was appointed, he joined the services. This part I will just skip because now your lordship will kindly come to page 20. Page 20 is the charge sheet, your lordship. Memorandum of the charges and the witnesses. This was on 10/2/2015. So after about 10 years of service, he was served with this charge sheet. I'll just read this, your lordship. This is not very long. With regard to force so Constable Peon Bijit Borua. Here they have stated as Peon. Deployed at Group Center, CRPF, Salbagan, Agartala, a proposal for the undersigned to inquire into the charges against him under Rule 27 of 7 so and so
Being a member of the force, he disrespected the orders, negligence of his duties, other negligence of indictment of misconducts related to the inquiry was proposed. The detailed list of the charges is attached as provision 1. Being a member of the force, he disrespected certain things, negligence of duties, negligence in performance of duties, or any other misconduct, description of acquisition of charges attached to as provision 2. List of documents of witnesses on the basis of charges are proposed to be proved as provision 3 and 4. For so-and-so Constable Peon Bijit Borua is being directed that when he receives the letter of memorandum, he should reply within 15 days in his support and presence of witnesses, and also reply to the authority as to whether to hear him personally or not. After providing the charges of the deploy as well as a copy of it served to him, and after giving a minimum time of 48 hours, the inquiry will start. It has been informed to Peon Borua so-and-so that if he himself is not present before the investigating officer, otherwise, Rule 27 of the CRPF rules would proceed in accordance with proper rules and regulations. He refuses to follow obediently the orders, then it will be considered that according to arrangement given under the rule, then he would not be considered for reasonable behavior for inquiry. And in such a situation, an ex parte inquiry will be conducted against so-and-so. Under Rule 20 of the CCS conduct rules, it was specified that in accordance to the said rules, no government employee in support of his service will influence any senior authorities or political power, etc. I'll not read all these, Your Lordship. Then these are all actually translated from Hindi. So there may be some, I don't know, because I have difficulty in that. So, Your Lordship, page 24 are the charges. The force so-and-so constable so-and-so deployed in group center so-and-so being a member of force is served under the Section 11 for disrespecting orders, negligence of own duties, other negligence in misconduct behalf. Above all, he remained absent from duties with effect from 17/12/2014 to 19/12, then 2/1/2015, 7/1/2015 to 10/1/2015, and 20/1/2015. So overall, it is in total about 8 days. In intermittently 8 days during this period, without any sanction or permission from the competent authority, which is regarded as violation of rules of CRPF, accordingly is punishable for the offence under section so-and-so. Then second, Your Lordship, force so-and-so, Assam, has neglected his own duties, disrespect of orders, misconduct, behavior shown, unauthorized absence from duties without permission from the competent authority for several times, even after offering him several opportunities and imposing the minor penalty to reform him, but he acts against the good arrangement and discipline of the force, and so these are against section so-and-so of the CRPF. So basically, the whole issue was with regard to absence for 8 days intermittently during that period, and
Unauthorized.
unauthorized absence without permission. So due to which they say that the second heading comes on the basis that he has neglected his own duties and disrespect and misconduct on the basis of the absence from duties. Basically, these are the two grounds on which he has been, Your Lordship. Then again in page 26, there's given the description of the charges in detail, Your Lordship. Page 26. Yeah, I may read it if Your Lordship wants that I can read that too.
Yes.
Here the description is in detail. According to CRPF rules so-and-so, being a member of the force is bound by his duties, and he must be disciplined, dedicated to truth, and perform proper conduct, present himself as high class, which will be an example for others. In fact, he was in leave for total 14 days due to some emergency with effect on so-and-so, and therefore on so-and-so early morning, he have to give his attendance. On 17/12/14 at around 10:30 am, he arrived in the office, but again at about 11:30 am, he left without taking permission from the competent authority. Above all, he remained absent till 19/12/2014 from the office. Again on 2/1/2015, it has been found that he remained absent in the office and not in the range of any phone connection because he switched off his mobile phone. And on 3/1/2015, he came to the office.
You might have enjoyed the 31st in New Year.
Actually, the main issue here, Your Lordship, is that this person,
Free and post 31st and 1st of January.
that part I don't know.
Celebration.
But
You are busy in preparation for 31st, then post, you are after the party.
Post-party hangover.
Post-party.
Anyway,
Yes.
actually, my whole case, basically, my ground was that it's a very interesting case you will see on the ground, because other than that, I cannot see anything very visible from the records. But the ground is that this person who is married to a lady, and since he was posted outside in Agartala, his wife ran away with somebody else. So he had become very depressed and was into drinking and all.
Yes.
And so this all happened because of that. It is on affidavit I have stated that.
Wife running away.
Yes. With somebody else. So he went into depression. In fact, there was treatment for depression which I have annexed. And on the basis of which there was these absence and all. And ultimately he admitted that he was absent without permission, and he has asked for forgiveness and all. But they have taken the ground that no, since you are without your permission, you are absent. Therefore, in this intermittently for these 8 days,
Yes.
therefore they have terminated his service. So my first ground was that the termination is actually improper, shockingly disproportionate. That point was one of the points I'm trying to raise in this matter. So this is what it is. This is the grounds that has been given, that he came to the office on that day, but he went back. Then he was absent for 2 days, then like that 1 day. This way he was absent for 8 days. So basically that is the issue. Secondly, with regard to disrespect and all, he did not do any other disrespect except being absent from the duties. This is the basis of the case. Your Lordship, I'll not read the whole thing, Your Lordship. It has,
You just give the, what is that?
then Your Lordship will, yes. Please, the enquiry officer was appointed on 10th of March 2015. That is at page 34. I'll not read that. We are not challenging anything on that ground. Then Your Lordship, again, the said enquiry officer did not attend, and therefore another enquiry officer was appointed. And then Your Lordship, enquiry was conducted, and here Your Lordship will find at page 36 is the new enquiry officer was appointed subsequently after 10th of March. Then Your Lordship will see. One thing, Your Lordship, I have taken a ground that the enquiry report have not been, in fact, provided to me in this case. But actually, everything was in Hindi. So whatever has been translated to me, I can only argue before Your Lordship. The one ground that I have taken, apart from the shockingly disproportionate, the another ground was that the enquiry report was not forwarded to me. So that was not annexed in this case, Your Lordship. The enquiry was conducted, Your Lordship.
What's
And
the inquiry report?
that was not provided to me. This is my case, in fact, one of the grounds of the case, is that enquiry report have not been provided to me.
This is page 37 is the
This is the
impugn order.
impugn order of removal from service.
Yes.
In fact, in the affidavit in opposition filed by my learned friend, they have also not annexed the enquiry report. In that case,
Page 50 is
page which page?
page 50.
50 is the rejection of the revision. I have, after the appeal, then I filed an appeal on appeal, then I filed a revision. So
Where's
there
the
are three authorities which I should.
Where's the appeal?
No, I filed an appeal. Appeal has not been annexed, but that was rejected. Then I filed a revision. The revision is at page 48.
50.
Appeal was rejected. I filed a revision petition. So revision on at page 48, that is 8/1/2016. Then your lordship, at page 50 is the revision order, which also rejected. Now the first, I'll just read the order of removal because that will give a overall description of how they went through the page 37. I'll read that first because that is important. First point that I raise here is that the enquiry officer's report was not provided to me. In fact, your lordship, in the affidavit in opposition also, they have not annexed the enquiry report. That also they have also not annexed. I was not provided, so I could not annex. They have also not annexed.
I have the record with me, my lord. I have the record with me because the inquiry papers were.
If you have not furnished the inquiry report on this
No,
call,
no, my lord. The inquiry report was furnished to him on 6th
Show
of
us.
July.
show us.
He received it. Yes, from record also. I have
You
the
have the
records.
record?
Yes, I have the
You have the
record.
record?
Yes, ma'am.
Okay, that will come. Now, your lordship, second part. Because they have not stated in the affidavit, that's why I am not sure. Page 37, office order. On 10/2/2015, a memorandum served force number so and so, so and
It's
so. so.
okay. Why you should go into all this thing? You just tell us the grounds.
The main ground, your lordship, was that number one was
No inquiry report was furnished.
were not furnished, but they say that that has been furnished and he
Just give
received
the
it.
ground. That's what we consider.
That what he said. I'm
So
taking
first
it on
ground-
his
first
yes.
ground
Number
is-
one. Then your lordship, I'll
No,
take
no,
this.
no inquiry report was furnished.
Yeah, that was first point that I have taken. And secondly, your lordship, there was the whole decision was based on the ground that he has pleaded guilty. He has pleaded guilty before the enquiry. But in fact, your lordship, as per my instructions, he pleaded guilty under the fear of persecution. So that is one point that I have taken because it was before the authorities concerned.
Otherwise, there's an admission.
Yes,
You
it's an
plead-
admission.
pleaded guilty.
It's an admission, but the ground for that was taken that it was under fear of persecution. That, whatever your lordship, but I have to make my, he has stated, whatever the petitioner has stated, I am just pointing it.
I understand.
And secondly, your lordship, one point that was also taken is that the cross-examination was not done and no assistance was taken of any other authority. That part, your lordship, they have filed in the affidavit that he was given the opportunity to actually have somebody else
Now,
as.
once you have pleaded guilty, nothing remains.
Then
It's a
your
cross.
lordship, then if
And
everything
it's-
goes
even
in,
if it's no cross, will it be fatal?
no, that is fatal
First,
or
you
not.
have to overcome the
What is
pleading of guilty.
normally what happens, your lordship? I'm just making my submissions in a general manner. What happens, your lordship, in a departmental enquiry? It is basically the enquiry officer, presenting officer, the person concerned. Now, what has happened? He is in the force. It was a CRPF force. And normally, what happens? The officers rub them, are very strict and all. They are very afraid of them. What happens in that case? Since yes, the absence was admitted to the next day that he was absent, but there are grounds for his absence. The grounds for his absence was not considered. What I have stated here, that was not considered. The second part was that he admitted the guilt on the ground that otherwise he may be persecuted. He was in the fear of persecution. He's under fear. He admitted. These are the grounds, reasons I am giving you. Then your lordship, the third part, your lordship, comes. Regarding the cross-examination and the person, there is normally one person to assist the person, the petitioner should have been given. They have stated that he was offered, but he did not accept it. I have taken a ground, but that ultimately they have stated in their affidavit that he was offered to take somebody's assistance. He did not take. And
Defense assistant.
assistance of
No defense assistant.
no defense assistance. And then your lordship, due to the, because he's just a PN, an uneducated or a very low category person. So fighting the departmental inquiry in front of senior officers, it was difficult for him, so he could not actually put forward his case clearly because the admission was there initially. Then the grounds on which the absence have taken place, I have stated, Your Lordship, that this was the, and he was even suffering from mental disorder. These are the reasons which he could not be highlighted in the enquiry. These are the grounds which he has taken. Here, Your Lordship will find one more thing that I would like to point out. At page 57, 58, he has, Your Lordship, was in even hospitalized due to the mental unsoundness.
Why this is shockingly disproportionate?
Shockingly disproportionate because of the two things, Your Lordship. Number one, the person was
Under depression.
under a depression. He was under treatment. In fact, he was under treatment, and in my, I think I have a deputy reply from him. So in fact, I have got a lot of medical documents which clearly shows that he was under medical depression, though only one document has been annexed in the writ petition as an 58.
Under medical treatment for depression.
Yes, he was under
Then-
medical
then-
treatment for depression for a long
then
period
next-
of time.
Next,
So these are the ground, because that was on the ground that his wife has eloped with somebody else.
though pleaded guilty of
He, in fact,
absence, but then there's no
due to
disrespect or disobedience or negligence.
there is no disobedience as such. He was absent without permission. This was, they in fact have taken only that ground. That I was absent for 8 days intermittently on various different dates. That was the ground taken. And because of that ground, without permission, they said that since you are absent without permission, therefore it is disrespect to the force. So that was the ground. That was the ground. But other disrespect like fighting with others or not, it is not it. He is also an alcoholic. He has become an alcoholic due to the depression with his wife and all. He had some issues of alcoholism and all. That was also there. That was also there. These two grounds, taking into consideration these two grounds, he was absent for a few days. Ultimately, he admitted to these and have also sought forgiveness from them. But ultimately, the inquiries happened and he was removed from service. Basically, overall, this is the case. Then, Your Lordship, what I have seen from the records that he had
Is there any violation of the rules? No.
rules directly, Your Lordship, I cannot say there is any violation
Then-
because
Then
what
it's okay.
that I cannot say.
Any decision?
Shockingly disproportionate decision I can give, Your Lordship. Today, in fact,
It is-
I did not bring any decision. I was in fact not
It
very
is not
prepared
re-
anyway also.
It is not required. It is because this is not shockingly disproportionate. In fact, it is. In fact, once you pleaded guilty, what may be the
Yeah, they could have given a punishment.
why-
I
that's-
understand. Punishment
that's why-
should have been
that's-
given to him,
Sir,
but
that's
not that removal from service of a
that's why
person.
removal, not dismissal.
It's a removal from service, but they could have given
Where
him
are you
a,
now?
Huh?
Where are you now?
at home, Your Lordship. And he's now again,
Whether hopefully
and
you
there's,
are
this is also, no, he's not,
recovered
he is now recovered.
from
Yeah.
everything.
He has recovered from all your
Including-
Lordship. It's long back because this happened in 2015, 16.
Including any recovery of the wife. No.
No. Wife ran away and she did not come back. He is also unmarried now. He's even 45 plus now, I think 45, 46.
45, 46 young man.
So, but he has not remarried. That I have got.
He is 45, 46 now.
Now I think he's about that age. Exactly. Because, let me see. No, he's not 45, 46. 8 years. Around about 40, 41, like that.
Young man,
40,
Right.
41 years of age. Not 45, sorry.
look for
He's about 40, 41 years of age now.
look for greener pasture.
The only thing that was that something lesser punishment was deserving. He could have been given some
32 years, that point.
At that time, 32, it was in 2015. So
16.
now around 16, now around 41, 41. So these are the grounds. Specifically, I do not argue on other grounds. It's not.
Yes.
meet with Lordship. Here basically his grounds are first, he was not given a defense assistant. Second, yes, second, I'll come to
I
records.
don't know why.
Yes. And second, the records are in vernacular in Hindi.
How do we know? In that case,
Yes,
you have
sir.
to translate.
Otherwise, let me submit. What happens, basically his case, Lordship is understood. And what I've understood is this, defense assistant was not provided to him. Records reveals that, he was asked to appoint a defense assistant. He refused. But, after the conclusion of departmental proceeding, inquiry report was furnished to him, asking him to make his representation. That was on 6/7/2014. On 14,
Is these records are in Hindi?
yeah, or in
Yes,
Hindi.
everything is in Hindi. Even
You-
I
you-
could
you
not go through.
translate it.
I'll do it.
May
Yeah.
not be on the may not the inquiry report.
The relevant portions were.
relevant person.
Yes.
You just type. Have
Yes.
you annexed that all those things?
No,
Statement
we have
in
not
your
annexed all the
affidavit?
documents.
Why you have not? That is very important. Once we find that the inquiry report is not furnished to the delinquent,
But we have made a statement in the.
no,
Yes.
then this is the. We don't have to go any other grounds.
Yes.
So show us that the inquiry report was
Yes.
furnished.
Yes. But it is in Hindi, may I
Is there
translate it?
any signature?
Yes, endorsement is there.
Receipt.
Yes, yes,
Show him.
yes. This is
So, Mr. Mannan,
on
whether it's your signature or not.
6th July it is. Receipt on 7th.
7 July. There is something receipt is there in Hindi and all. His name is there.
He signed in Hindi.
No, he signed and something is
signature-
written in Hindi, but his name is written and there is a signature.
English. So you are not disputing.
No, I cannot hear it. If it is on record, how can I dispute it?
You flagged it.
Yes, I have read it. So this is the
Date is
report.
there.
Yes, 7 7
Have you mentioned in your affidavit that so and so that it was furnished?
Yes, I think yes, we have mentioned.
No, in fact,
He has
Yes.
received it.
Let me check it.
that date is different and whatever they have stated is different. Lordship will kindly take up at page 7 of the affidavit in opposition.
Page.
Page 7, paragraph 16.
Affidavit.
Paragraph 16. Because that date is different.
There are 16.
Yes. Here, your lordship, with regard to the statement made in so and so paragraph so and so, was appointed inquiry officer, so and so, so and so, so and so, conducted the departmental inquiry against the petitioner, so and so, as per procedure and DE proceedings duly completed in all respects, has been submitted by the EO by his letter number so and so. During the inquiry, statements of prosecution witnesses were recorded by the inquiry officer before the delinquent, and keeping in view the principles of natural justice, several opportunities were also given to the petitioner delinquent to cross-examine the PWs at every stage of the inquiry. But the delinquent neither cross-examined any PWs nor submitted any defense document to prove his innocence. Copies of statement, questionnaire of all PWs were also handed over to the delinquent at the time of recording the statement by EO. Further, keeping in view of the principles of natural justice, copy of final report of inquiry was handed over to the delinquent on 1/5/2015 by the inquiry officer with direction to submit his defense, if
Yes.
any, within
As per the
15
record,
days.
when it
But
was.
that is here what then the record shows it is 7/7.
The Lordship may kindly
7th
come to
of July.
para 18. In para 18, we have mentioned about this inquiry report.
A to key होती है, 1/5
It was after the conclusion of
also
the.
handed over to delinquent on 01/05/2015.
2015.
It was after the examination of witness was done, he was asked to provide his defense.
within 15 days.
Yes, it was regarding that. It was before the preparation of the final
was
report.
also handed over to delinquent.
Yes, yes, but it
The
was
copy
handed.
of the report of inquiry
Final
No,
report
was
of the
handed over.
inquiry.
The language is different. Otherwise, from record reveals that the inquiry report was prepared subsequently.
Inquiry report.
Yes.
inquiry report.
And para 18, Lordship may kindly come.
Yes, there are.
Yes, Lordship may kindly. Yes, That with regard to the statement made in para 8 of the petition, the answer department begs to state that after receiving the inquiry report from the inquiry officer, my lord, here it's very
You
clear.
have to admit if you have mistakenly given this, you could have mentioned this also.
No,
It
here,
also said copy of the final report of the inquiry
Yes.
was also handed over to delinquent on 6/7/2015. You could have said so here.
well, here have,
Now,
we have
they have
stated.
stated in another paragraph.
Yes, in para
No,
18.
no,
Two different
two
dates.
different dates are
No,
there.
that is, my lord, because record would show, my lord.
Are you admitting it's a mistake or it's a correct?
Which one, my lord? On,
Para
yes,
16.
that was given to him. It was before the preparation of the final report.
Then why you have said that the copy of final report of the inquiry is also handed over?
That
to
is a
delinquent?
typographical mistake. I admit that. Because otherwise para 18 is very categorical, my lord.
So you want that the mistake should be ignored and the correct one has to be accepted.
Yes.
Is it possible?
Well, because this is very clear. Lordship, may kindly see
cannot be-
para 18, my lord. Lordship, may kindly come to
Sir,
para
you
18 for a
cannot
moment.
be casual.
No, my lord. I'm sorry for that.
Matter of the life of a person.
My
a
lord, I'm
young
sorry.
man.
I'm sorry, my lord. But Lordship, may kindly come to para 18, my lord. That will make very
I
clear.
have seen it.
Yes, because after receipt of the inquiry from the inquiry officer, it is very clear, my lord. But in para 16 doesn't say so. Copy of final report of the inquiry was handed over to the petitioner respondent. Delinquent by respondent number 4, by letter number so and so, date number so and so. The letter number is here. In the letter dated 6/7.
Yes.
Yes.
Then next.
That is one. Second, my lord, he is a habitual offender because it is not for only for this instance, my lord. He has done this. In 2012 also, my lord, he has made the same, my lord, he has committed the same offense. For that,
Was
my
there
lord,
any complaint or any inquiry?
yes, inquiry was there.
In
He was
2000
given his 20 days quarter guard in 2012. In 2013, your lordship will find here in page number 27 of the petition. Yes,
Don't easily say that habitual offender.
yes, 2013 also, my lord.
Habitual offender is to hurt in more.
Yes, I'm sorry, but
Unless
he is.
it is- unless it
I'm
is
sorry to
proved.
use it, my lord, but he is.
Unless it is proved.
Yes, I'm coming to that, my lord. In 2013 also, he had committed a similar offense, but he had overstayed leave for 9 days.
Why-
And
why
my lord,
not
D was
concerned?
initiated.
We are not concerned.
Yes, D is initiated, my lord. D was initiated and he was given a punishment of stoppage of 3 annual increments, my lord. In 2013 also. And again, yes, and again in 2014-15 he does this. Well, it is his habit of my lord, overstaying
Where
leave.
is that punishment?
Yes, lordship will kindly come. We have studied now affidavit also.
And he said he was under depression.
No, that is also recorded in their affidavit. And he has stated that before the authorities, they have stated in the paragraphs 18, they have stated that.
20 also.
Yes.
Yes. Then
My lord, this is one. Then here, my lord, in 10 years of service, my lord, he has overstayed for more than 30 times. Here, my lord, is a clear case of admission. Again, my lord, when the inquiry report was furnished to him on 6th of July 2015, my lord, on 14th of July, my lord, he writes a letter to us admitting his guilt. He says, my lord, and my lord, that is admitted by the petition and the petition also.
where it is?
It is here in the record.
Have you stated that in your
Yes, yes.
affidavit?
Yes,
Where it is?
yes. Lordship, may kindly come to para 18 again.
Huh?
Para 18.
Did you say except you will give the commitment that you will not repeat?
So in reply, the petitioner delinquent submitted an
Okay,
application.
he has fairly submitted that.
Yes. He is admitted, madam. So, my lord, I have one judgment of my own High Court, my lord. Division bench judgment, my lord, of CRPF, my lord. My lord, squarely covers my case, my lord. This is my lord, 2000, my lord, 17 to, I am having a Supreme today, my lord, print out. 2017,
By this court?
yes, division bench of this court, CRPF personnel, on the same offense, my lord.
2000?
17, Supreme Guwahati 176. GLR is 2017 to GLR 543. I'm having
One.
pardon? My lord, yes, I am having Supreme today.
2017, one GLR.
No, 2017 Supreme Guwahati.
You say GLR.
Well, the GLR is a cross citation. I am not having that. This is my lord Supreme. Lordship may kindly see para 5. Yeah.
Yes. Para?
Para 5. Lordship may kindly see para 5. My lord. Here also, my lord, the disciplinary proceeding was done in accordance with law. My lord, in accordance with law, my lord, inquiry was submitted. My lord, we furnished the copy to him, asking him to make his representation. Thereafter, my lord, he makes his admission that yes, due to my lord, marital discord, my lord, he was mentally upset, so he consumed liquor and remained on. My lord, he remained upset. This is what he has admitted.
Regarding the earlier 30, your lordship, what my learned friend said, the 30 times he has taken leave, that was regularized by the authorities themselves. So once it has been regularized, you cannot say that he has done something
But again,
wrong.
2013 also he did the same thing.
Well, that para 20 itself, your lordship, can see.
Farooq Ahmed.
Admission of guilt.
Yes, there also was admission of guilt. Here also he was punished early.
No, no, very case.
Charge.
Absence. মই খালি এইটো দেখাই দিম এই কৰিব লাগিব কিছু মই মানে I am not very
Look. Para 5.
Yeah, I've seen that. Here, what it was for 93 days overstaying of leave. A very long period, your lordship, about 93 days. So more than 3 months. In this case, it is 8 days. And second part, your lordship, my learned friend is saying that his past record is not good. That also I'll just point out that the past record, whichever they have stated that he was absent, they cannot go into that because of one ground that they himself said that it has been regularized. That period which he was absent for 30 or whatever days, they say, that has been regularized. Once it has been regularized, you cannot say that he has a bad past record. That is what paragraph 20 of the affidavit in opposition, your lordship will see that. It is there, they have stated. It is also observed from the past record, the petitioner was habit of deserting the camp without.
Not going to all this.
No, because they have stated, so I am saying.
Required. Whether he is official, well, I'm concerned about the present proceedings only.
Yeah, present proceeding, because he has taken that ground of his past proceeding because he was absent, so and so. So considering everything, so that part, if they're considering my past record, then this part cannot be taken into consideration because they have regularized this absence. They've stated that which was earlier regularized by the competent authority by taking a
Problem
lenient.
is You have pleaded guilty.
No, that,
You have admitted.
that I have pleaded guilty, but here is a case, but this case I am
It's being a
distinguishing.
discipline force. There's a judgment of this court also.
No, this judgment says that he was he was earlier punished. The difference is there. It is in para 5 itself, it says.
Even, my lord-
That he- 1 minute. Earlier the
No,
it
no,
says,
there is a judgment of this court also.
yes, what I'm trying to distinguish the judgment, just a moment.
No,
This
no, not
judgment,
this judgment. I'm saying there is a judgment by this court also.
yes. So that's it.
On CRPL.
That judgment of this court in para 5, which my learned friend has referred to, has stated that he has deserted for 93 days. So there is a difference of 3 months and more, and 8 days intermittently, number one. Secondly, your lordship, in that case, your lordship, he was found to be a habitual offender. And on that ground, there was a award of punishment of stoppage of annual increment for 2 years without cumulative effect. These are there in that. In this case, it is not there. In this case, this date, what they have stated 30 times, 30 days or 30 times, whatever it may be. In that case, they have regularized that period. Once it is regularized, you cannot say I'm an offender on that. If tomorrow I am absent and after a period of time, my absence was regularized, can you say that I was absent? No, it cannot be said because that has been regularized by the authorities. You regularize it. Oh, yes, if I am punished for that, then you can say, yes, there was a punishment, you have been punished, and therefore you are a habitual offender. That cannot be inferred in this case. This is what I am trying to point out from the judgment which my learned friend and referred and what is there in the affidavit in opposition. That's what I am saying. And rest, your lordship, I am leaving it to your lordship.
Should I kindly come to my affidavit once again, my lord, regarding that stoppage of,
Okay.
yes, stoppage of,
You
my
mark
lord,
those.
yes, yes, I will do it. Stoppage of 3 annual increments, my lord,
Mark those
after DE, it is there in the
Mark
affidavit.
those records.
My lord, I will do it.
But subsequently you have regularized it.
Only one offense is 2012. So for 2013, our staying is concerned, my lord, stoppage of annual increment for 3 years, it is there. We will also kindly take up my affidavit, annexure 6, page 6, para, my lord, 12,
Para 12.
yes. Lordship, may kindly turn to page 6, the relevant portion is at page 6, my lord.
Okay.
Is there?
You just give the
Yes.
record.
My lord, I'll give it.
Flag it.
My lord,
Can you flag it?
my lord, I'll do it.
That's all. Mr. Mannan.
Yes. What else can I add?
Heard Mr. Y.S. Mannan, learned counsel for the petitioner. And also heard Mr.
M.R. Adhikari.
M.R.
Adhikari, my lord.
Adhikari, learned standing counsel,
CGC, my lord.
CGC, for all the respondents. Right?
My lord.
Challenge made in this writ petition is to the imperial order stated 1808-2015, 11-12-2015, and 11-3-2016, passed by the penalties by commandant, passed by the commandant group center CRPF Agartala. Then appeal by whom? Appeal by whom?
Appeal by me. Your Lord.
No, appeal rejected by, dismissed by which authority? Because you have not
Just
annexed that.
kindly verify. Because that copy is not here.
And the Inspector General of Police, CRPF,
Inspector General of
Tripura Sector
Yep, my
Headquarters.
record of
You just give that
Yeah, I'll
appellate
just-
authority, name of the appellate
Yes.
authority.
It's very difficult
Very
because
bad.
everything was in Hindi.
The petitioner has been
No, ऐसा नहीं है, ऐसा
Yes, sir.
imposed with a penalty of removal from service.
Sorry, Your Lordship, it is there in my paragraph 9. He filed an appeal before the Deputy Inspector General of Police.
Deputy Inspector. The three authorities, Burman? Three authorities. Deputy Inspector of General.
Deputy Inspector General of Police, DIG.
Deputy Inspector General of Police, CRPF, Agartala.
Yes.
And upholding the removal. Upholding the penalty of removal. By the correspondent authorities.
The appeal was rejected on 11/12/2015.
No, that's I told you. And the revision 11.3, no?
Revision was filed before the respondent number 3, that is
The
deputy. No, that has to be revision. Can you get it? It is before the Inspector General of Police, page 48.
brief text of the case. The petitioner was appointed as follower peon enter Central Reserve Police Force within the CRPF in South. A hearing after report to the CRPF in South by dated 12/05/2005. Said that Inspector General of Police Indian Records Official NES CRPF Jorhat Assam. Accordingly, the petitioner given service wisdom. The petition was transferred and posted at Group Center, CRPF, Salbagan, Tripura, in the year 2013. And continues to serve at the seat at Lesson Posting at Agartala. Well, the petitioner was serving a memorandum of charges where is the memorandum?
Memorandum at page 30, sorry, page 20,
24.
20 is the first memorandum.
Okay. Memorandum.
Is 20.
Memorandum of issue.
24 are
Till 0
charges.
15. Which I put it here in page 20. Huh? The details of the charges against the prisoner was also annexed. Page 20, which is quoted here in below, page 24. And then the description at page 26. After completion of the inquiry, the Deputy Inspector General of Police, Group Center here has passed the interim audit, 2015, where the petitioner has imposed the penalty of removal from the service. Not commanded, not the inspector. In terms of the Rule 28 of the CRPF, the Central Reserve Police Force Rules 1955. What is the relevant page imposing penalty?
That is at page, I think, 37. 37.
No, this is the first page. Relevant paragraph.
Page 39, Your Lordship. Page 39, para 8. There are serially 1, 2, 3, 4. Today on so-and-so, Constable P.N. Borua punished as removal from service. Deployed by CRPF. These are all actually translated from Hindi.
That's the problem.
Yes.
By imposing the
I have to go by what is there.
penalty of removal from the service to the petitioner. On the Mr. Yes. Continue. Pass the order. There's no, you are not alleging any violation of the rules, CRPF rules.
No, I am not alleging any violation because in fact,
Have you flagged it?
Yes, my lord. I have flagged that. Lord.
This is my note also.
the inquiry report which was furnished to him,
No,
which he had acknowledged, and his reply, my lord.
Yes.
In fact, I actually challenged the part with regard to the non-furnishing of the inquiry report, as well as the assistance was not given. In both these cases, it has been shown that in the affidavit as well as that it was provided. Therefore, these two grounds on the basis of the procedural irregularities goes. The only thing remained is with regard to the leniency and other things. But the past service part I have already stated, they have regularized them. And secondly, your lordship, this is only 8 days. And thirdly, your lordship, I have specifically stated, and they have also stated in their affidavit, that this person was suffering from mental problem, and he was under treatment of psychiatry department, even in Agartala during his service, as well as after his service in Dibrugarh Medical, in Assam Medical College, Dibrugarh. Because I'm sorry, because the additional affidavit was not filed in this. Sorry, reply was not filed in the case, and so this was not brought on record. I have those documents. If your lordship wants, I can also give the documents with regard to his medical documents.
It's not required. Even if you have that thing, you know.
No, that has been stated. It has been stated.
If
But
that is the case, you are not fit again.
no, that he has been
If you have
ultimately
your
fitness
psychiatric
certificate. No, their fitness certificate has also been given.
That relevant point of time.
Yes.
Since you have not brought on.
Now that's been given at that point
You
of
have
time.
not brought on record. You cannot.
I should have, but I cannot say what can be done. Sometimes these things happen. This matter.
So now you have the fitness certificate.
No, it is there.
Where?
No, it is not on the record, but a bunch of just now I've got a bunch of documents which I should have filed by a reply, which there should have been mentioned that he was under treatment all throughout at that point of time when the allegations were there, and then subsequently he was treated. He was dismissed. He went to Dibrugarh. He was treated, and then a fitness certificate was given. One is in Agartala fitness certificate, one from Dibrugarh. Both fitness certificate has been.
You have not enough time. There was it is of 2016
See, sometimes
Even before the
matter.
yes,
sometimes your lord
After
say
completion, it's very difficult.
sometimes we
even before the proceeding, my lord, he could have stated.
Would you like to give him a chance to file those documents?
No, it's a case of, my lord,
Bring on
no,
record.
they will never give that. There's no use.
which of offender Rashid has dictated the order also.
No, I have not completed.
Yes,
I just
understand,
recorded
my
the
lord.
facts.
But we filed it in long back in
Even I have not
2016
recorded
itself, my
your-
lord.
I have not recorded your submission.
Yes.
I just recorded the facts.
Yes. No, it will not
they-
be of any help because, my lord, I have one judgment of Supreme Court 2008 which says, my lord, there is no bar to, my lord, consider the past misconduct also. 2000 AR 2008 Supreme Court 375. I have the judgment also, my lord. Because here, my lord, it was not for the first time. Yes,
I'll consider the judgment provided you give him a chance to bring on record those documents.
no, my lord. I leave it your lordship because, my lord,
Anyway,
yes, oblige, my lord.
it doesn't look nice. Once you have completed.
Sometimes we have to
So I'll see.
see. These
I'll
are
see.
poor people, your
That's
lordship.
why
I cannot
I'll
say
apply
beyond
my-
that.
Apply my
My,
mind.
my,
Only point is
According
that
to you, no case.
my lord. Because, my lord,
And
the only thing I would
try and proceed.
yes,
only
Yes,
prayer
but-
that I will make here is a leniency on the basis of equity. At best, I can
That
say.
is to be considered by the authority.
Yes.
Authority has already,
That the authorities
has
can
already
consider.
rejected.
They could have.
my only case is, my lord,
You
had
go-
it been a
go-
first instance, my lord,
We'll
I
go
think,
by the law.
yes,
Yes,
my lord.
yes, that is the difficulty we face here.
That's why I'm repeating that is there any allegation of violation of the rules? as
That
such?
your lordship, from
Yes,
the
my lord.
records, these two rules that are violation, I have stated, they have said that they have done. They have filed their affidavit and brought on, or the records will reveal those. Anyway,
Oblige, my lord.
Thank you.
not so close.
Yes, what is the matter?
My lord, I am ready, but I am say to say, sorry, my lord, my learned friend, my lord, on the other side, she has gone certain surgery, my lord. So she is paying some accommodation.
Lordship, my senior Miss Egan has gone through a surgery, Lordship.
What is the matter?
Matter, my lord, is relating to, my lord, certain, my lord, the equality and equal treatment in the grave, my lord. They are being the trade of the empty driver. Earlier occasion,
You are drivers.
Yeah, drivers, my lord. They came before a lordship because, my lord, the earlier certain provisions were there that as per their rank, my lord, as per their promotion, their ranks was about conferred rank and base, and other facilities were given. But after merging of the, my lord, first empty driver ordinary grade, that was the promotional grade was the leading hand. That was the merger. The new category of 3 drivers has come. So one is the ordinary category, one second is the grade 2, then grade 1, then another special grade that was created. So 3 categories of drivers has come. So during that procedure, my lord, the procedure that was earlier followed, that regarding giving the rank and badge as per their promotion, that was withdrawn. So because of which they were deprived from all military, my lord, regards and the amenities as per their rank and badge. So they came before a lordship. And lordship, my lord, by hearing all the things, has given certain direction to the authority concerned to comply the only to mitigate the grievances of the petitioner. That did to some extent, but not in the full strength and vigor, my lord. That is why we came before your lordship again. So there is some discrepancies in implementing the order also, and the other facilities consequently we are not getting and deprived. Well, this is the case, my lord.
Okay, what to do?
Let's pilot.
It's 2016 method.
Yes, yes, that is why not in the my lord insisting on any agenda because whenever he is in the handicap position, I have not any say to say. My lord. So let the matter come after the first week of the January, my lord.
Mr. P. Mahanta, counsel for the petitioners.
I am for the petitioners.
Petitioners.
Petitioners, sorry.
Next paragraph. MS.
P. Rabha on behalf of Mrs.
P.
Agan.
Rabha.
P. Rabha.
Rabha. And counsel appearing on behalf of
Agan. Agan.
Agan. Learning CGC. Learning CGC. CGC submits that MS Agan is under medical treatment.
Yes, sir.
He has undergone one surgery.
Yes, Lordship.
Under medical treatment. Therefore, request for accommodation of 3 weeks. 3 weeks.
The first week of January.
3 weeks. They are not being opposed to by the council for the petitioners. And considering that the CGC is under medical treatment, let this matter be listed after 3 weeks.
My lord, first week of January.
As a last chance. Last chance. 2016.
Then, my lord, one date, maybe possible to give a date, my lord. On the January 7 or 8 is, I think, holiday. 8 of well, 8 only. 8 January. Mass of bless. This is our minute.
Taking one second.